Hello landlords, this is Matthew Lyman welcoming you back to the Landlord Advocates. Right now there's currently a bill being proposed in Congress that would be quite detrimental to all landlords all across America. Let's talk about it. This bill is called the Rent and Mortgage Cancellation Act of 2020. It is H.R. Bill 6515. It has been proposed and authored by Representative Ilhan Omar of Minnesota. There is also some co-sponsors on this bill that, as you see right now, are scrolling across your screen. A lot of the applications of this law I'm going to go over with you now. And when you get done hearing what I have to say, you're going to be calling your representative and telling them no on H.R. 6515. Some of the propositions are during this COVID-19 pandemic crisis that tenants do not have to pay rent to you at all during this whole time frame. And that during that time frame, you cannot do certain methods, do certain acts against them, because if you do, there's trouble down the line. You cannot take this debt that they owe you and apply it towards a credit score if you try. You cannot go after them, you cannot attach it to any debt. You cannot go after them in court for this money. You cannot evict them for money that they owe you in this rent. You cannot do that. You cannot take them to court for repayment of that rent. You cannot evict them in court for not paying the rent to you. If you were to try to do that, and obviously it would be proof that you did when you get a docket number on the court documents, the tenants are served, they consult with an attorney or a tenants' rights advocate group. If they prove that this has happened, the first offense is a $5,000 fine. The second offense is a $10,000 fine. The third offense is a $50,000 fine or forfeiture of the property. Therefore, you can't do anything. You can't say, you're not paying me the rent during this crisis, I'm going to evict you. And if you do it, you're in trouble. The Attorney General will actually be the one that will be prosecuting you for doing these things. That is not fair. That is just not fair. But there's hope in sight. There's hope in sight for you, the landlord. When the government says that the tenant does not have to pay you, they have a proposition called the Landlord Relief Fund that you can petition HUD, the Housing and Urban Development Office, through the federal government to recoup the money that they send to the tenant. You don't need to pay your landlord. You don't need to do that. We will take care of it for you. That all sounds fine and dandy, but there are so many stipulations to this that when I tell you what they are, you're going to cry. You're going to cry. You would have to enter into a binding agreement with HUD for 5 years in order to get this money that these tenants owe you. During that 5-year time frame, there are certain things you cannot do. You cannot discriminate based upon their source of income as to how that rent would be paid. Now here in New York, that already is the case. You cannot say no to Section 8, you cannot say no to the Department of Social Services, or some call it welfare. You cannot say no to them. In New York, you already cannot do that. You have to have what's called a just cause eviction. We know non-payment is obvious, non-payment, that's just cause. Here in New York State, they're looking to push that law as well, a just cause eviction, which means just that. You have to have a cause to evict. It cannot be as simple as, I don't like my tenant anymore, I have somebody else I want to move in, I don't want them there anymore. That's a just cause eviction. And the biggest part of it is called a rent freeze. you cannot raise rent for 5 years. How is it that you can't raise rent for 5 years on that dwelling? We all know that the expenses of running that building or that apartment is going to go up in price. Materials, labor costs, repair costs, hot water heaters, appliances, a new roof, taxes, insurance. All of these are expenses that you and I all know are going to go up. So for them to tell us you can't raise rents for 5 years, come on. Now part of this as well that they have in here that you cannot do as far as new vacancies. If you have a new vacancy, you must let the Public Housing Authority know that you have a vacant apartment. Well, they don't say how you have to do that. They don't say for the duration of time that you have to leave that apartment open for somebody who might be in public housing, a Section 8 voucher, in order to acquire that apartment that you're renting. It doesn't say how long. A big part is the admissions restrictions that you have. You may have parameters set up that you say, I don't want the tenant for this, I have stipulations to this. Some of those stipulations you can no longer consider with renting to a prospective tenant. One of them is sexual identity, sexual orientation, gender expression. This is 2020, people. Does that really matter? If a tenant has a different sexual orientation or gender expression, that really shouldn't matter. Come on, we know that. But some of the other factors that they have in here that do matter, illegal, or I should say immigration status, whether they're really an immigrant or illegal immigrant, you cannot determine that. You cannot use that as a factor to not rent to the tenant. You cannot look at their arrest record. I can kind of go along with that because you can be arrested. Doesn't mean that you've been convicted. Oh, but wait a minute. Part of this law says that a conviction record cannot be considered. Jaywalking? Sure. Spitting on the sidewalk? Sure. But conviction record? Does that include murder, rape, robbery, burglary, arson? Anybody that's been convicted of that, and yes, people do get reformed, yes, people change their lives. But this act says that you cannot use that as a determining factor as to say no to a tenant. Another part of this act that they're saying that you cannot use, which most landlords use now, it's used a lot here in New York, is the credit history. Credit history and credit score. They're saying that you cannot use that as a determining factor in basing it as a decision to accept somebody as a tenant of yours. Here in New York, another aspect that you cannot use is prior evictions. Here in New York, you can't say, well, you've been evicted 3 times, 4 times, 5 times, I don't want to rent to you. So a lot of landlords here are using a credit score as a basis of determination of whether they want the tenant or not. This here says for 5 years, you can't do that. There was a recent study done in 2017 that there was $480 billion paid in rent across the United States. Well, we know this is 2020, that amount has increased, we know that. So the federal government is going to assume all of this rent for this duration of time. How many billions of dollars is this going to cover? How many landlords are going to be willing to adhere to these awful stipulations in order to recover 2 or 3 months worth of rent from a tenant? Most of you are going to say it's just not worth it. I'm going to let it go. But if your tenant happens to pay you that April, May, June, because this law would be retroactive to April of this year, April 2020, they pay you April, May, and June's rent. The federal government, if you choose to enroll in this landlord relief fund, you will get reimbursed minus the amount of rent that the tenant paid you. But here's the caveat. The federal government will actually send a check to your tenant for the rent that they paid you for that time frame. Now, as well, this law does not take into consideration your income level as far as saying, no, you're not going to pay rent. So you might have a tenant who actually makes a lot of money, who is not unemployed at the moment, somebody who is actually working, somebody who might be making a ton of money, and they're saying that, no, that doesn't matter. We're going to waive all of the rent and they don't have to have it. Now, part of this law refers to lessor, lessee. Lessor, landlord, lessee, the tenant. What she did is on her website, Iliad Omar, Representative Iliad Omar, on her website, broke it down a little easier for people to understand. And in that she mentions that this money would only be available to those who have an existing lease or an existing rental agreement. Now here in New York, an existing rental agreement minus the lease is the rent receipt. The tenant agreed to pay the rent to you, you agreed to give them a place to live for a certain amount of month for that calendar month. They paid it. That's proof in court that there's an agreement between you and the landlord, you and the tenant, to stay living in that apartment for the duration of time that they pay the rent to you. So this law says you have to have an existing lease, and it also mentions an existing rental agreement. Is that one and the same? Well, she's saying an existing lease has to exist. And in New York State, as in many states, you don't need to have that lease. You don't need to have it. That's it in a nutshell as it pertains to landlords, my friends. As is quite evident to you, hopefully by now, this is not a law that we as landlords, we as landlord advocates want to pass. Therefore, notify your local legislators. Notify them all and tell them that you are against H.R. 6515, known as the Rent and Mortgage Cancellation Act of 2020. Landlords, we are so happy to be able to provide you this information that we hope that you will subscribe to our channel, that you will say, yes, we like what landlord advocates have to say, and we want to hear more. Until then, take care.